With the election of Governor Rauner, we once again are hearing much about so-called workers' compensation reform. Reform, by any measure, sounds like a good idea if the thing that is seeking to be reformed is broken or needs fixing. In 2011, the Illinois Workers' Compensation Act was significantly amended and reformed in order to satisfy the interests of business seeking to reduce the cost of providing workers' compensation to workers throughout Illinois. Apparently those reforms were not significant enough because once again Governor Rauner is introducing new reforms that still further will limit the benefits available to workers injured in Illinois, limit the access to medical care, and limit the recovery they can make from a work-related injury. I think before examining reform and the reforms that seek to change the act or fix the so-called broken system, it's important to remember where we came from and how this law was created and what its purpose is. Prior to the enacting of the Illinois Workers' Compensation Act and similar state statutes throughout the United States, workers in the U.S. faced a very difficult environment. So too did employers. If an individual was injured in the workplace prior to the enacting of a state workers' compensation act, their only recourse was to sue their employer in a civil court based on a theory of negligence. When bringing a negligence action, an employee must show and establish that somehow his employer was at fault in causing their injury. Frequently, this was difficult. Frequently, an individual was injured through no fault of their employer or no fault of their own. It was simply an accident. And when this was the case, and when those injuries were devastating, the injured worker had no recourse. Frequently, if these injuries were serious enough, the worker would ultimately be unable to return to work, unable to pay their medical bills, and would become a ward of the state. When one becomes a ward of the state, they become a recipient of social services. When they become a recipient of social services, the entity that pays those costs and expenses are you and I through our tax system. With the enacting of the Illinois Workers' Compensation Act, the state legislature clearly sent a message that they wish to place the cost of work injuries on those individuals that were in the best position to prevent work injuries, employers. This approach was superior to the system where an individual had only the civil courts to look to, only recovered if they were able to establish negligence, and otherwise would be required to rely on other sources of assistance in response to their work injury. Likewise, prior to the enacting of the Illinois Workers' Compensation Act, an environment existed for business owners that was difficult as well. If an individual sustained a catastrophic injury, and they were able to establish that their employer was somehow negligent or at fault in causing their injury, they would turn to the civil courts and recover damages not only for their lost wages, not only for their medical expenses, but for pain and suffering both during and after the injury. Frequently, these awards or verdicts would be several times the net worth of the business, and it would result in the business being unable to pay that expense, facing bankruptcy, and having a catastrophic effect on their cash flow. As a result of this environment, an environment that was bad for employees who were catastrophically injured but could not establish negligence on behalf of their employer. Bad for employers who, when negligence could be established, faced outcomes that were difficult to pay. The system that was developed in response to this is called the Great Compromise. A compromise because an employee in Illinois need not establish fault, but, good news for the employer, there are limits on what an injured employee can recover. Therefore, the Great Compromise. As we have heard the word reform echoed again and again by conservative politicians seeking to diminish the rights of workers, we forget the Great Compromise. More and more is being taken each day from the injured worker. There's been no resulting slide towards increased liability for employers. The doors to the circuit courts have not been opened, allowing injured workers to sue where they could establish negligence. They're barred from doing so. So it appears employers continue to enjoy the benefit of the Great Compromise, while at the same time, injured workers are asked to sacrifice more and more each day. If I said to you today that Illinois spends more per pupil educating their children, how would you react? If I told you today that Illinois spends more money seeking to rehabilitate veterans injured in the line of duty, how would you react? If I told you today that Illinois dedicates more resources to treatment of the mentally ill than any other state, how would you feel? Why then, when someone tells us that Illinois spends more than many other states on their injured workers, do we react with such great disgust? As a state, we've made a conscious decision to take care of our working people that are injured in the workplace. Let's not be aghast at what we pay. Let's be proud of what we pay. Illinois is a state where the state legislature has made a conscious decision to take care of their people that are injured at work. Let's quit stripping the rights of the people we depend on the most in the name of reform. Let's continue to take care of our good people legitimately injured in the line of work.